to be audible. So thanks for coming today. My name is Brandon Butler. I'm from the University of Virginia Library. I'm the Director of Information Policy there. And here, Jack, you want to introduce yourself?
Sure. Well, that's what happens when you get too close to the metal plate in my head. I'm just kidding. There's no metal plate. I'm Jack Bernard, and I am in the General Counsel's office at the University of Michigan.
So we're going to talk to you a little bit today about something that we worked on. Jack and I were part of a big discussion that happened earlier this year, and then I wrote up, I think, kind of the core consensus points from that discussion into a white paper. And we're out sort of spreading the good news today about copyright law and how copyright law actually facilitates accessibility. It is not a barrier to accessibility, it is an enabler to accessibility. So this is sort of the money quote from the very end of the paper. It's not going to be easy, right? The effort involved in ending the book famine for thousands of students and researchers will be substantial, and that is our goal. That is really our goal. It's that ambitious. It's not going to be easy. There will be challenges along the way, but copyright law should not be one of them, and in fact, it will not be one of them. And we'll talk a little bit about why. So here's where we're going to go today. I'm going to talk first, and I'll talk a little bit about disability rights obligations in higher ed, right? What do we have to do to respect the civil rights of the students on our campuses? And the global book famine, why respecting those civil rights requires that we take some pretty dramatic action with respect to the accessibility of texts. And then Jack's going to talk a little bit about the accessibility enabling features of copyright law. Copyright law is a pro-accessibility regime, believe it or not. How is the stuff that we do when we make works accessible legal? So we'll talk about the different doctrines in the law that favor accessibility, fair use. Section 121, also known as the Chafee Amendment. The Marrakesh Treaty, recently passed, and the DMCA exemptions, which are passed every 3 years by the Library of Congress. And then finally, I will say something about an initiative that Jack and I and our institutions are a part of called the FRAME Initiative, which seeks to begin to remediate the book famine by making millions and millions of digital texts into accessible versions available to qualified students and researchers on our campuses. So, what are the disability rights obligations of institutions of higher education, right? Well, disability rights laws do create rather broad obligations for us. We cannot discriminate on the basis of disability. And that we there is everyone, every institution. There are provisions in the Rehabilitation Act of 1973 for every institution that receives federal funds, which guess what, is all of us. We cannot discriminate in the provision of the services that we provide. The Americans with Disabilities Act, Title II applies to those of us at state and local government institutions. That means Jack and I in particular. And then Title III is for any public accommodation, and that sweeps in all of our private institution friends. And so there are laws broad enough to capture essentially all of us and to tell us that we must do the right thing by our students regardless of their ability. The risk here is substantial. You can lose federal funding. You can be the subject of a consent decree that will compel you to take steps to remediate and address the accessibility problems on your campus. And enforcement is happening, and it has been a bipartisan and a continuous effort. Believe it or not, the word on the street is even this administration and its Department of Ed and its Department of Justice continues to make this a priority. So the risk for institutions like ours of not providing accessible text to folks with a valid need for those texts is very real. We have to make policy changes that will address that risk and minimize it. The global book famine is also very real. There are, per WIPO, the World Intellectual Property Organization, 285 million blind or visually impaired people worldwide. There are many, 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 many more people with other kinds of disabilities that make access to print a problem for them. And yet, 1 to 7% of published books are available in accessible formats. And so my little graph there is the best case scenario, right? Assuming it's 7%, the maximum estimate, that still leaves a lot of people out. That leaves a lot of books that are not available at all in a format that's actually accessible. And so a story that I can tell very, very briefly, because I know we have a short time frame here, is about J.D. Salinger. Those of you who read about J.D. Salinger's works coming to the electronic format, there are different versions of why this happened. If you Google around, you'll find a few different stories, but one story that is frequently told by Matt Salinger, J.D. Salinger's son, is that he was motivated to release electronic formats because he got a letter in the mail from a woman who said, I am in my retirement, I'm a voracious reader. I have always wanted to read your father's books, but I sustained an injury to my arm, right? So it's not a print disability. This is another disability that makes the manipulation of a physical paper codex not possible. And she said, for the longest time, I had trouble reading at all, but ebooks have changed my life. But if you don't release these books in an e-format, J.D. Salinger doesn't exist for me. And so that's part of why Salinger's books are coming out in an electronic format.
Hey, can I say something?
For sure.
So I just want to add to this idea of the data there too. So the data include, as accessible formats, just audiobooks. But for many people who have disabilities, audiobooks are not an accommodation for their disability because most audiobooks are a performance, and many people who use sound to work with books, they want to be able to interact with the book in a different way than a performance will enable. And so those numbers are bloated no matter what you think. So what it means is that for this large population of people with print disabilities, whether they're vision impairments or mobility impairments, or certain kinds of cognitive impairments, it means that the selection of books is very, very, very small.
So whose job is it to help someone on a campus who needs an accommodation of this kind? Well, on most campuses there is an office, and we call them in my writing and in the writing that led up to the grant that I'll talk about later, the generic name we use is Disability Services Offices, right? And this is an office with dedicated staff. They determine whether a student is qualified, do they have a documented disability. They provide texts in accessible formats and other assistance, typically on this is on an ad hoc basis. It's in response to a request, one by one by one, to students. They engage, we found, and some of the researchers who did research leading up to the work we did, found that there are hundreds and hundreds of hours of needless duplicative work takes place in DSOs every year, remediating the same book over and over and over again, right? And then destroying the remediated version, giving it away to the student, and then having to remediate it again the next year. Often, when publishers do provide sort of remediated or semi-remediated texts, the DSOs reported that they have to do more work. The text is not typically completely ready to go. My colleague used some colorful language in a local newspaper. I didn't put it in the slide. I know there are many friendly publishers in the audience tonight, but she said publishers sometimes give us crap, and then we have to fix it. And it's a frustrating reality in DSO's offices. The quality of material they get is extremely variable. And most important for our talk today, these offices routinely cite copyright as a major barrier to their work. It is copyright that scares them and prevents them from repeatedly using the same file from semester to semester. It scares them from collaborating with other institutions and saying, we've got this, do you need it? Copyright is a major bogeyman for these groups. And indeed, right, if you look at the kinds of efforts that would be needed to make massive access to digital texts available for all kinds of folks, regardless of their ability, copyright does seem to be implicated, right? Massive scale digital collections are needed. We need lots and lots of books that are ready to go in order to efficiently provide access, and that means lots of digital books. And digitizing books and keeping them is a thing that copyright typically regulates. Reproducing and distributing these books for each student. Here you go, here's a copy, it's for you, from me to you. Those are both acts that, again, copyright regulates. Creation of derivative works, arguably, right? It may be that when you, in order to create a new version of a text that has an adaptation to it, arguably you're doing something that copyright might regulate. All of this done typically without permission, because seeking permission can be extremely difficult, if not impossible. Where the accessibility services do exist, provided directly by publishers, tight control is the norm, right? And so as a condition for receiving a remediated text, DSOs typically have to agree to do things like destroy this copy and then ask again if you want another copy. And so that has conditioned these offices to believe that, gosh, I had better watch my step when it comes to making accessible texts available. Luckily, though, it turns out that copyright is not all about stopping you from doing things, right? It's not all about total control for the copyright holder. Copyright is a balanced regime, and an example that I like to use is the First Amendment. We know from two big Supreme Court cases, Eldred v. Ashcroft and Golan v. Holder, that the First Amendment could have been a problem for copyright. In both of those cases, the plaintiff said, hey, you can't do this with copyright law. If you did, if you limit what I want to do using copyright law, that's a problem for the First Amendment. In one case, it was about extending copyright terms, and in another case, it was about restoring into copyright works that had risen into the public domain. In both cases, plaintiffs said, hey, you can't do that. The First Amendment says copyright can't work that way. And the court said, no, actually, copyright has built-in First Amendment safety valves that ensure that copyright does not come into conflict with the First Amendment. And so the right of free expression is guaranteed in copyright law by things like fair use, right? It says you can use someone else's work in the context of a new transformative use, right? You can express yourself. And so the Supreme Court said in both of those cases, essentially, it would be a real problem for copyright if it did not have those safety valves, but it does. Copyright must yield to this higher interest, and it does. And what we're here to tell you today is that the same dynamic plays out in accessibility. That is, it would be a very real problem for copyright if it were not consistent with accessibility. Copyright doctrines, however, ensure that copyright is not in conflict with the rights of folks that are disabled, right? Fair use, as applied in the Authors Guild case, is by far and away the most important. But close second is Section 121, the Chafee Amendment. And then we have the Marrakesh Treaty and the DMCA. Together, these four things create a kind of accessibility policy within copyright law that make it possible for us to respect the civil rights of our users and the copyrights of the rights holders in the works we use. And I'll let Jack tell you a little bit more about the copyright doctrine.
Should we swap spots?
Yes.
Thanks. Hey, everybody. So this slide is the most important slide that I have for you today. I do have a bunch of slides, but this is the most important one. It's the thing that I'm hoping everyone will leave the room with, this idea that copyright is not a barrier to making works accessible for people. It's perceived that way, and I think it's largely perceived that way because we only think about part of the story. And I will give you some examples of what I mean by that as I go further on. But I think we hear certain elements and then and stop looking at the rest of the act or stop thinking about what comes next. Because copyright is not just as simple as a party holds copyrights and that's the end of the story. And so it's really critical for us to think about these issues together. With that in mind, there are two really key points, which is, actually before I say that, I'll say this is important, this message on this previous slide here is important not only for people who want to make uses of copyrighted works to make them accessible. They're important for people who want to be the beneficiary of those uses. It's important for authors and publishers to know this as well, because otherwise we spend a lot of time taking umbrage about something for which there's no reason to take umbrage. The Association of American Publishers sent letters to campuses across the country saying, just remember, you can't make these kinds of uses under the Chafee Amendment, Section 121. You don't count. And people believed what they heard. And so there was a lot of confusion about this. And I think now things have been resolved quite a bit. And so we have this opportunity to kind of get people to spend time spinning their wheels on other things. Okay, so these two key points are, for the most part, if someone is going to make works accessible to people, make reproductions or make them works accessible to people because they're helping somebody who has a disability gain access to the work, you just want to make sure that you're targeting the people who need that access. And it does depend on the context. So if you're making a copy of a work and putting it in an accessible format, you want to make sure that only those people who need it in the accessible format are getting it. At times, though, there are other kinds of accommodations that are made broadly where there really is no efficient way to target the individual, say closed captioning in a movie or on television. That, everyone can benefit from that, but it doesn't really undermine the copyright holder's market, so there isn't so much of a problem there. But you really, in general, want to focus on making sure you can reasonably get works in an accommodated format to the people who need them. And the second point is, not everyone who has a disability is going to need an accessible version. And so you just want to keep that in mind. And you might be asking yourself how this can be true. Brandon talked a little bit about this, but think about copyright like this. There are these rights for copyright holders in Section 106 of the Copyright Act. And then there are rights for the public in Sections 107 through 122. And those rights for the public are kind of carved out of the copyright holder's 106 rights. And in the context of accessibility, the two most prominent rights you'll run into to make works accessible are Sections 107, which is fair use, and Section 121, which is the Chafee Amendment. The copyright holders have a fantastic set of rights, and this is what everyone focuses on when they think about copyright. This is a summary. There's 6 rights, and I've summarized them to be 5. These are really powerful, important rights. We should respect these rights. They're terrific, right? It enables all these fantastic industries. The publishing industry relies on this, the movie industry, music industry. It's a spectacular set of rights, and copyright holders get these great rights. What people don't focus on, though, is the other part of Section 106. And if you'll see in that kind of Kelly-ish green, well, actually, let's focus on the burnt orange first. The burnt orange tells you what the rights are. It's the right to do and to authorize these things. That's what you get to do as a copyright holder. You don't get all the rights in the world. You get these rights. And you get to do and to authorize those things. That's what you get. And they're fantastic rights, but that is what you get when you're a copyright holder. And those rights, those exist subject to, beholden to, if you look at my reading, subservient to the rights of copyright of the public, the rights in copyright, or that the copyright law grants to the public in Sections 107 through 122. People don't think about it that way, but they also don't read this part of the Act. They don't pay attention to it. They're only paying attention to part of the story. So it's useful for us to have that in mind. So this is what fair use looks like. It's Section 107. It's one of those rights that the Congress carved out of copyright for the public. This is what it looks like on the whole. People only tend to focus on these bits here, the 4-factor test. That's the part that everybody's excited about. That's also the hard part, because you don't know how those factors are going to come out. But the really important part, the part that doesn't change, where the analysis is pretty much the same every time, that's what we're going to focus on. This part of the story, that first paragraph. And if you look at the Kelly Green part, it says, notwithstanding Sections 106 and 106A. Notwithstanding. That means despite 106 and 106A. Despite the copyright holder's rights. And then if you'll notice in the kind of, I don't know, what color blue you would say that is. But it's a nice, pleasant blue, almost a violet blue. There's probably periwinkle. Maybe I heard someone say that. Periwinkle blue. Notice what it says. Fair use is not an infringement of copyright. It's that simple. It's just not an infringement. And if you look at the burnt orange here, you kind of get to see this idea that there are some uses that are really preferred here. Well, these are the kinds of uses that people make in the academy all the time. The criticism and teaching, research, scholarship, these kinds of uses are favored uses. It says it right here in the Copyright Act. Congress has authorized these uses as a right for the public. So useful to have that in mind, and we'll end up touching on this in another second, excuse me. Here are the famous 4 factors. I'm not going to go through all of them with you, but it's important to note that courts tend to be most interested in the first factor, the purpose of the use, and the 4th factor, how it affects the market for the original. These are pretty good metrics, although some cases the 2nd factor, which looks at the nature of the work itself, or the 3rd factor, how much you're using, those are relevant at times. Okay, then there's this part of the Copyright Act in Section 121 that says, hey, we don't want you to have to do a fair use analysis here. What we want you to do, if you are an authorized entity, which is a term of art, if you are an authorized entity, and you make works accessible to people who have print disabilities, or people who, in this case, print disabilities, people who have disabilities, you can take advantage of this section. And it says you're allowed to copy and distribute works in accessible formats if you direct them towards people who have disabilities. This is great. It's right in here. If you're providing services to people who have disabilities, fantastic. Now, not everybody can be an authorized entity. Most not-for-profit organizations have the possibility to do that, although not many dedicate themselves and have as a primary objective for their organization to do this. But it turns out libraries do have this, and post-secondary institutions do. And so we are able to rely on the chafe uses. And here you'll notice again, notwithstanding Section 106. And you'll notice here, again, not an infringement of copyright. It's not an exception, it's not a privilege, it's just not an infringement. Why? Because Congress carved it out specifically with disability in mind. So there's only one line of cases on this, and my institution was at the heart of those. And the line of cases really is just a district court case and a Second Circuit case, all about the same matter. In 2004 and 5, a bunch of universities started working with Google, including University of Michigan, to digitize works. We announced it in 2004 and 2005, and in 2005, Google was promptly sued. And then later on, in 2008, the University of Michigan started the Hadi Trust, which is basically an enterprise to let those colleges and universities that had digitized collections steward those works collectively, because it's more efficient to do it that way, and for the purpose of enabling services that would enable people to find works, to preserve those works, and from the beginning to make them accessible to our constituents who had disabilities. Just stop and think for a second. If you can't access books in the library, it's so much more difficult to be a student or a scholar, because you have to wait forever to get those books converted into an accessible format. And what we did is we said, well, look, here are some 17 million volumes that can now be immediately accessible to you, so that you can procrastinate just like everyone else does. And you don't have to wait for 3 months to get your works, and to even decide whether or not you want to use them. Okay, so eventually the Authors Guild is upset about this, and so they file suit against a bunch of Hadi Trust institutions, and there's a victory for Hadi Trust at the district court level, and then they raise it to the Second Circuit, and again, Hadi Trust prevails. And this is important because these are the only cases in the United States on disability and copyright. And so we know what the courts, the only courts to comment on this, think. And so what they ultimately determined in a very pro-publishing circuit, the Second Circuit, what they determined is that it can be a fair use for places like college and universities or libraries to make works accessible to people who have disabilities. And moreover, they acknowledged that this fair use analysis, it works hand in hand with other federal legislation like the Americans with Disabilities Act. And so the court focuses on these two elements and makes this pronouncement that yes, there's no question, these are fair uses. This is what Congress intended about fair use. It is important for you to note, though, that not any use accessibility use is going to be a fair use. You really do want to tie it to actually accommodating someone who has a legitimate disability. That's pretty much what will keep you in line, and I wouldn't worry too much about that. I'll say we got great language from the court. This is from the district court. It's the kind of thing, I mean, I actually cried when I read this the first time because it was so inspiring to me, the fact that the court paid attention to this great public policy notion that we actually do want people who have disabilities to be able to participate fully in society, and that the case that we put forward helped people, and the court in particular, to see this. It is also important to note that the district court looked at Chafee uses, and for the first time anywhere, a court said, yes, indeed, here is an example of an authorized entity. University of Michigan and its library are what we consider to be an authorized entity, or what I consider, said Judge Baer. The Second Circuit didn't acknowledge this commentary, but did not opine on 121. It disposed of the case just on 107, saying that because it was a fair use, it was fine. So just realize that the only case that discusses Chafee highlights an example of a college or university making accessibility uses like this. There's a question, yeah.
I'm just curious, does the law define what an authorized entity actually is?
Yeah, yes it does. So an authorized entity is a not-for-profit or governmental entity that has as a primary objective supporting populations of people who have disabilities. So things like libraries and disability services offices seem to fit in line there. Private for-profit entities are going to have a difficult time operating under Section 121, but they won't have a difficult time operating under Section 107 if they're really tailoring their uses. You don't have to be not-for-profit, you don't have to have that as a primary mission to be able to make a fair use. And so both opportunities are available. Something else that's important about 121 to note is it really focuses on literary work, so you really can't make people, you can't make works more accessible, say videography, you're not going to be able to make that more accessible under 121, or sound recordings, pictorial works, unless they're embedded in the literary work, you won't be able to make those more accessible under 121. So 121 is not a panacea, but it is an easier way to make the decision because you don't have to go through the fair use analysis. I'll just say a word here about the Marrakesh Treaty because that's happened since this HathiTrust case was decided. And it's just this nice expansion because of the global famine of books for people who have print disabilities. Again, this only focuses really pretty much on print disabilities and books and literary works. So again, other types of copyrighted works really are not included here, but it operates very similarly, and we now have Section 121A of the Copyright Act to address this. It's very similar to how 121 works because they were using 121 as a model, and it authorizes export and import that copyright sort of purportedly impaired previously. It doesn't create any new causes of action, and it does have a few additional requirements. So if you're working with sharing books or retrieving them from another Marrakesh country, you will want to make sure that you're paying attention to the small details, like that all the works that you're making available are to people with disabilities, that someone can see the list of those books and you're keeping records, but you don't have to keep records that would compromise an individual's privacy rights, and which is a very nice aspect of this. It's a great step forward, and another example of a time where a Republican administration signed very Very good law for people who have disabilities. The Rehabilitation Act, the Americans with Disabilities Act, and now the Marrakesh Treaty all got signed by Republican presidents. So don't assume that people's politics dictate how they think about disability. And I'll just pass this last little bit over to you.
Thanks, Jack. So I'll say a little bit about the DMCA. I've got some experience fighting about the DMCA. The Digital Millennium Copyright Act is a kind of, my friend Peter Yazzie calls it para-copyright. It's not copyright, it's sort of copyright adjacent. It creates a separate cause of action for someone who breaks the digital rights management or technology protection measures that are protecting access to a copyrighted work. And even where your use is otherwise lawful, if you have a work that is, for example, an ebook that has digital rights management that prevents you from opening it outside of its proprietary ecosystem, if you crack that digital rights management, even to do a lawful thing, that's a problem. That creates a separate violation in addition to a copyright question that you might have. And so every 3 years, there is a kind of special proceeding in the Library of Congress hosted by the Copyright Office, our friends at the Copyright Office, and they want to hear from us out in the world about particular cases where we are making lawful uses and the DMCA is a problem for us, where we fear that we will be in trouble for doing otherwise lawful things. And so for many years now, since 2003, advocates for accessibility have been winning exemptions from the Copyright Office, recognizing that it is appropriate and necessary to break the DRM on ebooks in order to make them accessible. And that exemption has been growing steadily every cycle since 2003. Most recently in 2012, it was expanded to include authorized entities, that's us. This is, I think, valuable primarily because, and then we see in 2018, similar to the Hathi Trust Court, the Copyright Office specifically recognizes disability policy in federal law beyond copyright. So the Americans with Disabilities Act, the Rehabilitation Act, as a reason to grant an exemption, as a reason to recognize that this is lawful activity. I think this is important to us only because it continues to reinforce that throughout the copyright system, and indeed throughout the legal system, there is a coherence favoring accessibility. And you know, by the way, right, the Copyright Office, not always the most friendly place for users, and so when you can win them over, you know you've really got a strong case, right? They recognize these uses are lawful, so that, I think that really reflects well. So taken together, right, what does all this mean? It means we know we have the protection we need to create and remediate a digital repository. Fair use lets us do that. We know that from the Hathi Trust case. We can massively digitize books and put them in a repository like the Hathi Trust, just in case, right? We don't even have to wait for a request. It tells us we can distribute text to to folks with qualifying disabilities under both Section 121 and fair use. It tells us you don't have to buy the book or prove that you bought the book in order to get an accessible text. That's clear in Section 121. There's no mention of a purchase required. It's clear in Hathi Trust, no mention of a purchase required. We don't have to destroy copies from semester to semester, year to year. And we don't have to put frightening, warnings, this book will explode in 60 days, and so on and so forth. So what are we going to do with this power we have, right? So all of us eggheads met in January. Why did we get together to talk about copyright, to find all of the arguments that we've just described for you? What's all that good for? Well, what it's good for is we're going to federate these repositories. We have multiple massive digital repositories, and we got $1 million grant from the Mellon Foundation to begin to bring these repositories together and leverage them in support of accessibility. And so we've got 6 institutions, libraries, DSOs, and presses at some of those institutions. So you see the roll call there, all working together. And we have these 3 massive digital repositories. The Internet Archive with 21 million texts from all kinds of places. The HathiTrust digital library, seeded by Google, but augmented every day by all kinds of sources, 17 million texts. And then we also have the Bookshare corpus and their expertise in accessibility as part of this program. 1 million titles created in partnership with publishers. And the goal of all this, all these texts already existed, and HathiTrust and Internet Archive have already been in the accessibility business, and of course Bookshare, that's all they're really, that's their core. All of these groups have been doing accessibility, but they haven't been able to talk to each other in a kind of hardcore, hardwired, technical way. And so the Frame Grant is going to let the experts in the libraries connect these repositories together, ensure that we are tracking what's been remediated and how, and make it possible for any DSO that participates to get access to the right thing, remediated in the right way, to serve the audience that they need to serve on their campuses. It's really exciting, and it's powered, again, not only by the texts, and not only by the libraries, and not only by the publishers, but by the law. The copyright law makes this possible, and we think it's really important for folks to understand that. So thank you all very much.
We'll definitely take questions, but if you don't have any, we'll provoke them. Yes, please.
So I'm curious about this sort of geeky copyright question. Why wouldn't 108E have been an elegant means of sort of supporting this? I mean, it also sort of brings in the is it available thing. And I mean, it's a work, and I mean, is it a work if the format is digital and accessible? You know, I mean, maybe that was the issue there. That it's like, well, you know, it's the same work kind of thing, but making it accessible would be sort of different. But it just seemed like, you know, that seemed like kind of a cool way to loop that in, also with libraries and archives. So immediately, we're the ones that are sort of should be the ones providing this. I'm just curious if that ever came up.
Sure. So the questioner asks about 108E, and you know, couldn't we use 108E? And you can absolutely use 108E, which allows libraries in particular to make copies of works for patrons under certain conditions. And so that's absolutely the case. It certainly could happen. Sometimes, though, the kinds of remediation we might engage in may require other uses that go beyond the scope of 108E. So I see 108E as being a part of kind of a federation of support. You can also look at section 109 for some uses that we might make. But yes, you're absolutely right. This doesn't impair any of the other sections, but just to give you an example of the kind of remediation that we think of. So an author writes a book and puts in graphs and charts and photographs, and we want to remediate the book so that the user can get a sense of the experience, maybe without being able to see the work. And so that requires then a description of those things. And this is the example you'll hear from like the National Federation of the Blind, the kinds of things they would really like to see. Also, kind of, there's some navigation elements at times that might facilitate the user experience in a way where the user is seeing things connected in a work in a way that you might not ordinarily see if you were just turning from page to page. And so these kinds of remediation definitely would count on us using section 107, but you're absolutely right about 108.
Yeah, and the only thing I would add about 108 is, right, you're supposed to sort of ensure that there's not a reasonable commercial version out there. And while section 107, the argument in HathiTrust makes reference to market and the general phenomenon of market failure that's certainly true in the book famine, we don't have to go for each particular request and say, is this one available or not? We have a general fair use right to just provide it. So that's important too, I think. Yes?
So this brought back very bad memories of copyright law in law school, and that whole idea of what copyright law stops you from doing. And so my question was going to be, well, everyone knows about HathiTrust, but are there more cases? And since you addressed that already, why is that? Is it because publishers know or vendors know that that case is there, it's looming? Is it because they're relying on this, what you guys talked about, this idea in universities that copyright law is a burden? So how is that going to change? Are we going to see some more pushback?
We both have theories. Well, so I mean, and I know, I've heard Jack say this kind of stuff as well. This is, I think a lot of us that work in universities, there are a few things that we think are behind the lack of lawsuits against us, right? I mean, one is, we're nice people and nobody wants to sue
looks
us,
bad.
right? Like, it looks bad, it's bad politics. Judges like us. We're too sympathetic. Another thing is, we're pretty conservative. We just don't take chances. And so, you know, maybe there'll be more lawsuits once we start really asserting our rights, you know, but so far we've been very careful, almost frankly, to a fault. And so that's a big part of it.
I think that's exactly right. Also, previously it was kind of a drip, drip, drip. So HathiTrust seemed to be more like a, just a tremendous deluge, right? And so rights holders were worried about that until you sat down and talked with them. And that's kind of an interesting experience too. I also think there was just a lot of misinformation out there. I think HathiTrust has cleared up some of that information. I think it's possible that we'll see new issues emerge in the future around this. You know, something to consider is what happens when publishers really commit on their own to making works accessible, as they have been able to do for at least 30 years, right? So we've got 30 years of this. This HathiTrust is a response in significant part to the fact that the industry just hasn't adapted. And there was real pressure for post-secondary institutions to make works accessible because you cannot meaningfully participate without access to the written word. Whether you don't have arms, or whether you have a mobility impairment, or a certain kind of cognitive disability, or you just can't see well enough. And so I think there is this potentially looming experience in the future when maybe 90% of the works are produced in an accessible format. What will that mean for fair use and for 121? I don't actually know. There'll always be a need for those things looking back. I wonder if there will be a time where there's just a year that's designated, where there's just enough. And that, you know what, I'm very happy to have that world, because if people with disabilities get to participate equitably in society, that's the win we're seeking.
Yeah.
Yes? You, sorry.
What do you guys think about the court case that's in California? I think with the community one of the community college systems where there's an OCR complaint or a lawsuit, and basically what the court decided was that the library has to go through and audit all of their database contracts, and any of the database providers that are not compliant with up to the standards of the WCAG standards, that they either have to show evidence of the vendors like working towards that, or cancel the subscriptions. So in terms of when libraries are trying to have these conversations with our vendors, and of course we need to provide the information that our students need to be successful as researchers, as learners, but conversely, when we're met with the library and the universities are the ones that are signing the contracts and really on the hook for this. So I'm just interested to kind of get your feedback on that.
Sure. So the question is about cases that are brought against institutions for having contracts with third-party vendors whose services aren't accessible, services or products aren't accessible. I don't know necessarily about the specific case that you're pointing to, but it doesn't matter, because it's just a nice example. So the challenge is that because most of the time this arises, the accommodations that these kinds of companies would have to provide would arise under the Public Accommodation Title III section of the Americans with Disabilities Act, because most of these entities won't be part of the Rehab Act. They aren't getting federal dollars, and so it's still, courts really haven't interpreted place of public accommodation for these entities to be their sales to another entity, like a college or university, sales of services or products. And so what smart organizations do is they sue colleges and universities, or they complain to the Department of Justice or OCR about colleges and universities saying, hey, you're creating an environment in which people don't get to participate. So since they can't go directly after the vendor, they go after the college or university. And we've seen this in many, many contexts. And so the pressure they put on, and they're oftentimes consent decrees or just letters of understanding, that colleges and universities will be making progress. What you're seeing lots of post-secondary institutions doing now is creating standards in their vendor agreements, basically saying you have to meet these standards, or you have to have a date by which you will meet them, or we will, payment will be reduced, or we'll find a new vendor. Very difficult, though, when you don't have an alternative vendor to go to, and because the university is stuck between a rock and a hard place. You want to do this cool, new, neat thing, but not everybody gets to do it.
Yeah.
So that's where the pressure is.
Yeah, and I'll just say from a from a policy point of view, when I talk about this issue, and again, right, lots of publishers in the audience tonight. I'm not trying to beat up on publishers, but with respect to the way that the disability policy treats vendors of information products, publishers, as Jack said, they don't get sued over this stuff. We do. And it's in stark contrast to the folks who own physical property, right? If you own a restaurant, your physical property must be accessible. If you provide public accommodations, you have, as a condition of your property right, it's carved out. You don't have the right to not have a ramp. You must have a ramp. And so when thinking about why is the copyright law carved up in the way that we've been describing, I think part of the reason that we have, as authorized entities, as entities with a mission to serve people on an equal basis, one reason we have the right to do things that ordinarily a copyright holder might control is that we have an obligation to use their property in that way. And they don't have that obligation. So if you're going to give someone rights without giving them a corresponding obligation, then you have to give someone else, the other, the folks who have to do the accommodating need to then have corresponding rights. We have to have that ability to intervene.
I just want to add a couple of things here to something you said made me think of this. Lots of publishers, though, now are moving into the realm, and I think this is a good thing, moving into the realm of providing online services. And all of a sudden, Title III is going to start applying them.
Yes.
We're already starting to see cases now against private entities, like, for instance, Target, that sells things online and provides services online, and it's not accessible. I do not understand, I admit it, I do not understand why an entity like Target, I shop there, would fight this case. Just fix your website. It's going to be so much cheaper than paying lawyers who make a lot of money, right? Unlike me, there's some serious lawyers working for them fighting about this, and I don't understand why they just wouldn't make their site accessible. It's just not that hard to do. So that's very peculiar. Something else I thought of is, and I think this is, again, only the part of the story, I have this part of the story theme I just imagined here. And I think another reason we don't get sued, to go back to the previous question, is because we are an amazing customer, colleges and universities. We literally spend billions of dollars a year buying content and books and licenses. Literally billions of dollars a year. And on top of that, we make our students buy billions of dollars a year in textbooks. And I just think we are excellent customers. We educate about these issues. We are thoughtful about these. Why? Because we respect the ecology. We actually want there to be publishers. We want them to be successful. We want there to be authors. We want them to be successful. Most of our post-secondary institutions have a ton of authors and many publishing outlets. So we think all of it is good. We need a healthy ecology. Yes, please.
You had mentioned Google, and that was a long lawsuit and snippets and this and that. Could you give a quick summary of how that started and where it ended?
Sure. So in 2002, University of Michigan began talking with Google about the possibility of having Google digitize our entire library. We were digitizing books at a rate of about somewhere between 5,000 and 10,000 a year, and we had 8 million volumes, and that was going to take us literally at 5,000 a year, 1,000 years to digitize the library so that we could preserve the corpus of human knowledge, which is what we were interested in. So Google said, I think we can do that in 6 years. So that seemed like a great thing. So we entered into a contract with Google in 2004. It took a couple of years to work all that out because we thought carefully about it. That Google then entered into agreements with a bunch of other post-secondary institutions, and the moment they announced it, they got sued shortly thereafter. That lawsuit was for Google digitizing stuff, sharing stuff with libraries, and making these snippets, kind of 3 lines, available. They spent many years trying to settle the agreement.
Is that the Authors Guild?
Yes, the Authors Guild and the
And the
Association of
publishers.
American Publishers.
Okay.
And some individual plaintiffs as well. And so for a change, authors and publishers were working together. It really took a Google library hybrid to provoke that strange alliance. And so they brought this suit. There were just years of trying to settle it. There was like a monster, hundreds of pages settlement that would involve for the whole class. And but the class, by the way, the class of authors that were represented here were the authors of every book at the University of Michigan Library that was copyrighted. So they tried to settle the case by having this settlement with all these authors, and the court basically said, yes, AAP and Authors Guild, you don't speak for all of those authors, so we're not letting that go forward. And for whatever reason, the publishers ended up settling with Google. They entered into a settlement with Google. The Authors Guild persisted, but they just were very slow about it. So our case had a chance to both start and finish in the interim of Google's case. And when the Hadi Trust case prevailed, it created a nice roadmap that made it really easy for the Second Circuit to support what Google was doing. They were showing snippets. That was different than what Hadi Trust did. But Hadi Trust was allowing full access to works for people who had disabilities, which Google wasn't doing. Otherwise,
That's not what Google started with, right? I mean, they were really looking at more commercial than just for disabilities, or what?
no, they weren't looking at disabilities at all.
Exactly.
And they still aren't.
Yeah.
Yeah, they're still not really focused on that. Their focus is on allowing people to discover works and pointing them towards the work so you can borrow it from your library or buy it. And actually, lots of small publishers benefited significantly, and actually large publishers as well. All of the publishers who were suing Google also had contracts with Google, just about. Because they liked the publisher program, they just didn't like the part of Google contracting with libraries and digitizing all this stuff. And I think it was just there were a lot of unknowns. And then the publishers kind of got smart about it and realized, oh, in the end, we can control this and we'll settle the case. Authors were a little more skittish, and so the suit went to the end. And it was good news for digital works, I would say. It's really, really great. Maybe we have time for one last question. I know we're supposed to let you go, but I thought I saw another hand. Yes, please.
Well, actually, it's not a question, sorry.
Oh, it's a comment.
I'm Michael Johnson, I work for Benetech, so thank
Oh,
you
great.
for the Bookshare shout out.
We love
And
Benetech.
also to let you know that we're addressing and then someday all the publishers will have everything. So we have a new program where we're working directly with the publishers. I had breakfast with Charles this morning, where the publishers can go through our process, get their workflow certified, and so books that come out, once you draw a line in the sand for the certification, they are fully accessible and they can be commercially offered. If we're successful, we won't need to give the books away because they'll be commercially offered.
Right, great. So we learned from Benetech, just for the record, that Benetech's actually already working on trying to help publishers have books be born accessible. And we'll say, we'll make, it'll still be a stepwise process, because as more people benefit from laws that protect people with disabilities, they're able to participate more fully in society, and there'll be new kinds of disabilities, people who were ordinarily not out in society, but who were staying with their families or institutionalized or any number of other places where they weren't getting a full education. I'm a legally blind person, and when I graduated from college, only 7% of legally blind or worse people had full-time employment, and only 14% were employed at all. So that's 86% of legally blind people between the ages of 22 and 65 who were completely unemployed. That's just a waste, right? It's a terrible waste, and it says something about our society's ability to let people participate. Those numbers have climbed. They're still not where we want them to be. I feel particularly fortunate, and it was all about education for me. And I think for lots of people,
this is the entree to participating fully in society, is to have access, to be able to go to school, K-12, the idea, and then go to college, ADA, Rehabilitation Act, to be able to participate fully in society, and this is what we want. So anyway, thank you for coming to this, and we appreciate your questions.